guilty as charged." Judge Malone's voice thundered through Courtroom 7B, each syllable striking like a gavel against the stunned silence. Marcus Johnson froze, disbelief washing over his face as the maximum sentence, 15 years, became his new reality for a crime he maintained he didn't commit. Before we jump back in, tell us where you're tuning in from, and if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. The imposing figure of Judge Eleanor Malone loomed from the bench, her slate-gray eyes narrowing as she delivered the harshest sentence permitted by law. Marcus Johnson, a 34-year-old black man with no prior felonies, stood motionless, his shoulders rigid beneath his carefully pressed suit, the one his mother had insisted on buying despite the financial strain, believing appearance might somehow influence justice. What Judge Malone didn't see was the woman in Seat 3A, Deputy District Attorney Vivian Parker, her dark eyes widening as she registered every microaggression, every shift in judicial language, her hand already reaching for her legal pad. Nor could the judge know that the defendant's brother, Dr. William Johnson, wasn't just any physician, but the chief of surgery at Memorial Hospital, who'd sworn an oath to protect the vulnerable, an oath that extended far beyond operating rooms and into courtrooms where his brother now stood condemned. Judge Malone thought she was establishing judicial authority over a defendant who dared question her ruling. In reality, she was igniting a chain reaction that would dismantle not just her career, but an entire judicial culture built on unchecked prejudice and presumption of guilt. The hushed courtroom seemed to pulse with tension as Marcus Johnson's attorney, James Rodriguez, rose to his feet. "Your Honor, we request a stay of sentencing pending our appeal." His voice, though steady, carried an undercurrent of controlled outrage that rippled through the gallery. Judge Malone adjusted her reading glasses with practiced precision, the same dismissive gesture she had performed countless times during her 17 years on the bench. At 58, her once idealistic approach to justice had calcified into something more cynical, a professional mask of impartiality that rarely reached her eyes anymore. "Motion denied," she replied, without looking up from her notes. "The evidence in this case is substantial, and the jury has spoken. Sentencing will proceed as ordered." Today, that mask felt particularly heavy as she surveyed the courtroom of case number CR 20257834, State v. Johnson. Her fingers brushed against the polished wood of her bench, the symbol of authority she'd once coveted with such passion when she'd first been appointed to the judiciary, fresh out of a prestigious corporate law firm. Back then, the power to shape justice had seemed the pinnacle of legal achievement. Now it felt like an endless parade of defendants, whose excuses grew more creative with each passing year. Most of them guilty, she reminded herself. Statistics don't lie. The recidivism rates, the demographic patterns. They told a story that 17 years on the bench had only confirmed in her mind. Preparing and narrating this story took us a lot of time. So if you are enjoying it, subscribe to our channel. It means a lot to us. Now back to the story. Defendant will be remanded immediately to begin serving his sentence. Judge Malone continued, her voice carrying the finality of someone who believed her judgment was beyond reproach. Next case. Marcus Johnson stood frozen, the reality of 15 years. 15 years crashing over him in waves. His life as he knew it. His job as an educational consultant, his community work, his plans to propose to Aisha next month. All of it evaporating in the sterile air of Courtroom 7B. "Your Honor," Rodriguez persisted, his normally measured tone edged with urgency, "there are significant evidentiary issues that warrant reconsideration. The prosecution's case relies almost exclusively on circumstantial evidence and a witness identification made under questionable conditions." Judge Malone's expression hardened. "Counsel, the jury has evaluated that evidence and found it compelling. Your objection is noted for the record, but this court's decision stands." As the bailiff moved toward Marcus, Rodriguez made one final attempt. "Your Honor, given Mr. Johnson's lack of prior record and strong community ties, we request he be permitted to self-surrender after getting his affairs in order." "Request denied," Judge Malone said, her tone clipped. "This court considers the severity of the crime sufficient reason to begin incarceration immediately." Marcus felt the cold metal of handcuffs closing around his wrists, the click of the locking mechanism echoing in his ears like a final punctuation mark on his freedom. He scanned the courtroom desperately, finding his brother William's face, seeing the controlled fury there, the silent promise that this wasn't over. As Marcus was led away, Judge Malone called for a 15-minute recess before the next case. She gathered her notes with the efficiency of someone who had already mentally moved on from Marcus Johnson's fate, already preparing for the next defendant in an endless procession. Eleanor Malone had grown up in an affluent suburb of Boston, the daughter of a federal judge whose dinner table conversations revolved around the importance of law and order. Her father's views on crime and punishment had been shaped during the tough-on-crime era of the 1980s and 90s, manifesting in declarations about certain neighborhoods being lost causes and certain defendants being, quote, beyond redemption. As a child, Eleanor had absorbed these views without questioning them. As an adult, she learned to keep such inherited perspectives carefully contained behind a professional veneer of impartiality. She considered herself fair, tough but fair, evaluating each case on its merits while maintaining the firm hand necessary to deter future criminality. "Is the Johnson sentencing complete?" her clerk whispered as she exited the courtroom. "Yes," she replied with a curt nod. 15 years as warranted by the evidence and jury verdict. The clerk's expression remained neutral, though something flickered briefly in his eyes. Doubt, perhaps, or concern. The defense seemed particularly adamant about their appeal grounds. Judge Malone waved a dismissive hand. Rodriguez fights hard for all his clients. It's admirable but ultimately futile. In this case, the jury was convinced beyond reasonable doubt. In her chambers, Eleanor removed her judicial robe, hanging it carefully on the wooden coat stand that had been a gift from her father when she was first appointed to the bench. Remember, he had told her, the robe doesn't make the judge gives meaning to the robe. She had taken those words to heart, believing her firm approach to sentencing gave meaning to her position, that her unwillingness to accept excuses or show unwarranted leniency protected society and upheld the integrity of the legal system, particularly in cases like Johnson's, where the evidence, while circumstantial, painted a clear picture in her mind. The armed robbery of a convenience store had resulted in the serious injury of the owner, a 67-year-old Korean immigrant who had identified Johnson in a lineup. The defense had questioned the reliability of the identification, citing poor lighting, the trauma of the event, and the fact that the perpetrator had worn a partial face covering. They had also presented alibi witnesses, placing Johnson at a community center meeting during the time of the robbery. But the prosecution had countered with cell tower data placing Johnson's phone in the vicinity of the crime, a grainy security camera image showing someone of similar height and build, and the victim's unwavering certainty about the identification. The jury had deliberated for just 4 hours before returning a guilty verdict. In Eleanor's assessment, it was an open and shut case, another example of the system working as intended. The defendant had received due process, been judged by a jury of peers, and now would face the consequences of his actions. As she settled at her desk to review documents for her next case, her phone buzzed with a text from her daughter, Catherine, a second-year law student at Columbia. "How's your day going, Mom? Any interesting cases?" Eleanor hesitated before responding. Catherine had increasingly questioned her mother's judicial philosophy during her law school education, adopting what Eleanor considered idealistic and impractical views about criminal justice reform. Their conversations about Eleanor's cases often led to tense discussions about systemic inequities and unconscious bias. Concepts Eleanor acknowledged existed in theory, but considered overemphasized in contemporary legal discourse. "Standard docket," she texted back. "Armed robbery sentencing, several motions hearings this afternoon." She deliberately omitted details about the Johnson case, knowing Catherine would question the harshness of the sentence relative to the evidentiary concerns. Their last argument about a similar case had ended with Catherine sending her links to studies about cross-racial identification, reliability, and implicit bias in judicial decision-making. Studies Eleanor had skimmed and dismissed as academically interesting, but practically irrelevant to her courtroom. Eleanor returned to the bench after recess, moving through her docket with efficient precision. By late afternoon, the events of the Johnson case had receded in her mind, replaced by the immediate demands of subsequent hearings and rulings. As court adjourned for the day, her clerk approached with a concerned expression. "Judge Malone, there's someone who's been waiting to speak with you, says it's urgent regarding the Johnson case." Eleanor's irritation flickered briefly. Case discussions belonged in the courtroom, Not in impromptu after-hours meetings. Who is it? Dr. William Johnson, the defendant's brother. He's been waiting since the sentencing. Eleanor considered refusing the meeting. There was nothing to discuss. The matter was closed until any potential appeal. But something in her clerk's expression gave her pause. 5 minutes, she conceded. In my chambers. Dr. William Johnson stood as Eleanor approached, his bearing carrying the natural authority of someone accustomed to making life-or-death decisions. Unlike his brother's carefully selected courtroom attire, William wore surgical scrubs beneath a white coat, suggesting he had come directly from the hospital. Dr. Johnson, Eleanor acknowledged with professional courtesy, gesturing him into her chambers. I understand you wish to speak with me, though I must emphasize that the appropriate venue for case discussions is through the appeals process, not private meetings. William nodded, his expression measured. I appreciate your time, Judge Malone. I'm not here to debate my brother's case specifically, though that is what prompted my visit. Eleanor indicated a chair opposite her desk, taking her own seat with the desk between them, maintaining both physical and professional distance. Then how can I help you, Doctor? William placed a file folder on the edge of her desk without opening it. Judge Malone, are you familiar with the Innocence Project's work on wrongful convictions? Eleanor's expression cooled noticeably. I'm aware of their advocacy, yes. Then you're aware that since 1989, more than 800 people have been exonerated after being wrongfully convicted of crimes they didn't commit. Many of them served decades before evidence. Often DNA evidence that wasn't available at the time of trial proved their innocence beyond any doubt. Eleanor folded her hands on her desk. Dr. Johnson, while I appreciate the statistics, each case must be judged on its own merits. Your brother received a fair trial, and a jury of his peers found him guilty beyond reasonable doubt. William leaned forward slightly, his gaze direct and unwavering. A jury influenced by a cross-racial identification made under stress and poor lighting conditions, with no physical evidence linking my brother to the crime, and despite multiple alibi witnesses. The jury weighed all of that evidence, Dr. Johnson. The system worked as designed. Did it? William's voice remained calm, but there was an intensity to his question that made Eleanor pause. Judge Malone, in my profession, when systems fail, when patients die unnecessarily or suffer complications that could have been prevented, we conduct rigorous reviews to identify what went wrong and how to prevent similar outcomes in the future. The legal system has appellate courts for exactly that purpose, Eleanor countered. Appeals that often take years while innocent people remain incarcerated, William replied. Appeals that can't evaluate new evidence not presented at trial. Appeals that, statistically speaking, overwhelmingly defer to the original verdict. Eleanor's patience was wearing thin. Dr. Johnson, is there a specific point to this conversation? Because if you're simply here to critique the criminal justice system broadly, I'm afraid I can't help you. William opened the file folder he had brought, removing a single photograph and placing it face down on her desk. Judge Malone, do you believe that eyewitness testimony is reliable? It can be, depending on the circumstances. Even when research consistently demonstrates that cross-racial identifications are significantly less reliable, even when the witness is under extreme stress, even when the perpetrator's face is partially obscured? Eleanor maintained her composed expression. Those factors may affect reliability, which is why they are subject to cross-examination and jury evaluation. William nodded. And what about when the actual perpetrator is caught on camera committing another, nearly identical crime, while the wrongfully convicted person is already in custody? Before Eleanor could respond, William turned over the photograph. It showed a security camera image, date-stamped 3 days earlier, of a convenience store robbery in progress. The perpetrator, face partially covered but eyes clearly visible, held a gun on the store clerk in a stance identical to the description in Marcus's case. This robbery occurred in Springfield on Tuesday evening, Williams said quietly. The perpetrator matches the height, build, and method of the person who robbed Mr. Kim's store. And my brother has been in custody since his arrest 2 weeks ago. Eleanor studied the image, her judicial mask momentarily slipping to reveal genuine concern. Has this been shared with the prosecutor's office? It was delivered to them this morning, along with preliminary analysis from a forensic photography expert comparing this image with the grainy footage from my brother's case. The patterns of movement, physical proportions, and even the stance are consistent with being the same individual. Then the appropriate legal processes will unfold, Dr. Johnson. If this evidence is substantive, your brother's attorney can file for an emergency hearing that will take weeks to schedule? For a review process that assumes the original conviction was correct until definitively proven otherwise? For a system that statistically favors finality over accuracy? William's calm facade cracked slightly, revealing the depth of his concern. My brother has already lost his apartment. His job is in jeopardy. And every day he spends in prison puts him at physical risk. Eleanor's expression remained neutral, though her mind was rapidly processing the implications. If what Dr. Johnson suggested was true, if there was even a possibility that Marcus Johnson had been wrongfully convicted, then her confidence in the verdict and in her own judgment demanded reconsideration. I understand your concern for your brother, Dr. Johnson, but I'm bound by judicial procedures. The proper avenue for this new evidence is through the prosecutor's office and defense counsel, not through an ex parte meeting with the judge. William gathered the photograph and file, rising to his feet. Of course. I simply wanted to ensure you were personally aware of the situation, given your role in my brother's sentencing. He moved toward the door, then paused. Judge Malone, in my profession, when we discover we've made an error in diagnosis or treatment, we are ethically obligated to acknowledge it immediately and take every possible step to mitigate the harm caused. We don't wait for committees or review boards or bureaucratic processes when someone's life and well-being are at stake. The implicit comparison hung in the air between them, the medical profession's approach to error versus the legal system's procedural caution, challenging Eleanor to consider which truly served justice. I'll contact the prosecutor's office directly, Eleanor found herself saying, the words emerging before she had fully formulated the thought. If this evidence warrants immediate review, I'll ensure it receives proper attention. William nodded, a flicker of cautious relief crossing his features. Thank you, Judge Malone. That's all I ask, that the system moves with appropriate urgency when someone's freedom hangs in the balance. After he departed, Eleanor remained at her desk, the conversation replaying in her mind. She prided herself on following proper judicial procedure, on maintaining the boundaries that ensured fair and impartial justice. Yet something about William Johnson's demeanor, the controlled intensity of someone fighting for a truth he knew with certainty, had resonated beyond her professional skepticism. She reached for her phone, dialing the number for District Attorney Richard Harmon. The call went to voicemail, not surprising given the late hour. Richard, this is Judge Malone. I need to speak with you first thing tomorrow regarding the Marcus Johnson case. There may be new evidence requiring immediate review. Please call me back as soon as possible. As she gathered her belongings to leave for the day, Eleanor's certainty in the Johnson verdict, a certainty that had seemed unshakable just hours earlier, had developed hairline fractures. Not enough to collapse her belief in the system or in her own judgment, but enough to introduce the uncomfortable possibility that, in the pursuit of justice, an injustice might have occurred. Eleanor Malone's heels clicked rhythmically against the marble floor of the courthouse corridor, each step echoing her growing disquiet. She had arrived unusually early, driven by a restlessness that had followed her home the previous evening and lingered through a night of fragmented sleep. The photograph Dr. Johnson had shown her, and the implications it carried, had wormed its way into her thoughts, challenging assumptions she had considered unshakable just 24 hours earlier. District Attorney Richard Harmon was waiting outside her chambers, his typically confident posture now tinged with visible tension. At 52, Harmon had built his career on high conviction rates and tough sentencing, a record that had earned him both political advancement and Eleanor's professional respect. "Richard," she acknowledged, unlocking her door. "Thank you for coming early." "Your message sounded urgent," he replied, following her into the office. "Something about new evidence in the Johnson case." Eleanor gestured to a chair as she took her seat behind the desk. "Dr. William Johnson visited me yesterday after court. He presented what appears to be compelling evidence that the convenience store robbery for which his brother was convicted may have been committed by someone else. Someone who has continued a pattern of similar robberies while Marcus Johnson has been in custody." Harmon's expression tightened almost imperceptibly. "Judge, with all due respect, defense families often grasp at straws after a conviction. Dr. Johnson is understandably upset about his brother's sentence. "I'm aware of that," Eleanor replied, her tone cooling. "I'm also aware that new photographic evidence was delivered to your office yesterday morning. Evidence that, according to Dr. Johnson, shows significant similarities between the perpetrator of a recent robbery and the one in the Johnson case." Harmon shifted in his seat. "We received some materials, yes. They're being reviewed by our team, but preliminary assessment suggests the similarities are superficial at best." "I'd like to see that assessment," Eleanor said. It wasn't a request. "Of course," Harmon replied, though his hesitation was noticeable. "I can have it sent over later today." "Now, Richard," Eleanor countered, "this matter deserves immediate attention. A man is sitting in prison based on a conviction that may be fundamentally flawed." "Judge Malone," Harmon began, his voice taking on the measured cadence he used for difficult jury addresses. "Marcus Johnson received due process. A jury of his peers evaluated all the evidence and found him guilty beyond reasonable doubt. One grainy security photo of another robbery doesn't invalidate that process." Eleanor studied him, noting the defensive posture, the carefully modulated tone. After 17 years on the bench, she had developed a finely tuned sense for when attorneys were being less than forthcoming. "Richard, let me be clear. If there is credible evidence suggesting Marcus Johnson may be innocent, I expect your office to treat that possibility with the utmost seriousness and transparency. Justice isn't served by maintaining a conviction at all costs." Something flashed in Harmon's eyes, irritation perhaps or concern. "My office has always been committed to justice." "Judge Malone, you know that." "Then demonstrate that commitment by providing a full and immediate review of this new evidence," Eleanor replied. "I want to see everything. The new security footage, the comparative analysis, the witness statements from the recent robbery, by noon today." Harmon stood, his professional mask firmly in place, though tension radiated from his posture. "I'll have my team prioritize this review, but I should caution against rushing to conclusions based on defense claims that haven't been properly vetted." After Harmon departed, Eleanor remained at her desk, an unfamiliar disquiet settling over her. Throughout her judicial career, she had prided herself on certainty, on rendering decisions with confidence in their correctness and finality. Now that certainty had been replaced by questions that refused simple answers. Had she rushed to judgment in the Johnson case? Had she allowed unconscious biases to influence her evaluation of the evidence? Had her faith in the system, a system she had dedicated her career to upholding, blinded her to its potential fallibility? Her phone buzzed with a text from her daughter. "Saw an interesting case study in criminal procedure today about cross-racial misidentifications. Made me think of our conversation last month. Love you." The timing was unsettlingly coincidental. Eleanor set the phone down without responding, her mind turning to the Johnson trial and her own role in it. She had dismissed defense arguments about the reliability of the victim's identification, considering them standard procedural objections rather than substantive concerns. She had allowed certain prosecution evidence while limiting defense testimony about alibi witnesses, citing procedural rules that, in retrospect, she might have interpreted differently. Most troublingly, she recognized now that she had approached the case with an unconscious presumption, not of innocence, as the law demanded, but of guilt. A presumption influenced by 17 years of seeing primarily guilty defendants, by statistics about recidivism and crime patterns, by her father's views on law and order, and perhaps by subtle biases she had never fully confronted. The realization was profoundly uncomfortable, challenging not just her judgment in one case but her self-perception as a fair and impartial arbiter of justice. By 11:30, a courier delivered a sealed envelope from the District Attorney's office. Inside was a thin folder containing a single-page preliminary analysis of the new security footage, concluding that, while certain superficial similarities exist between the perpetrators of the two robberies, these are insufficient to establish identity or to call into question the validity of the Johnson conviction. The brevity and dismissiveness of the report struck Eleanor as suspiciously inadequate. Where was the detailed photographic comparison? Where were the witness statements from the new robbery? Where was the evidence that should have accompanied any thorough review? Eleanor reached for her phone again, this time dialing the number for Marcus Johnson's attorney, James Rodriguez. "Mr. Rodriguez, this is Judge Malone." I need to speak with you regarding potential new evidence in the Johnson case. Rodriguez's surprise was evident in his voice. Judge Malone? I wasn't expecting to hear from you directly. I understand. This is an unusual situation. I've been made aware of security footage from a recent robbery that may have relevance to your client's case. Have you seen this evidence? Yes, Your Honor. Dr. Johnson brought it to my attention yesterday morning. I've filed an emergency motion for review with the DA's office, but haven't received a response yet. Eleanor's concern deepened. The DA's office claims to have conducted a preliminary review finding insufficient similarity to warrant further investigation. Did they contact you about this assessment? No, Your Honor, they haven't, Rodriguez replied, his tone sharpening. And with respect, that conclusion seems premature at best. The similarities are striking. Not just physical appearance, but specific behavioral patterns during the robbery. I've engaged a forensic image analyst who indicates the likelihood of these being the same perpetrator is extremely high. I'd like to see that analysis, Mr. Rodriguez. And I'd like to schedule a hearing on this matter for tomorrow morning. Tomorrow? Rodriguez sounded genuinely shocked. That's extraordinarily fast, Your Honor. If there's a possibility an innocent man is incarcerated, Mr. Rodriguez, then ordinary timelines are inadequate. 9 o'clock tomorrow. My courtroom. Please ensure your forensic expert is available to testify. After ending the call, Eleanor sat back in her chair, aware that she had just taken an extraordinary step. Judges rarely initiated review proceedings, particularly with such urgency. Her action would raise eyebrows throughout the courthouse and potentially draw scrutiny from the Judicial Ethics Committee. But the alternative, allowing bureaucratic processes to grind slowly forward while a potentially innocent man remained incarcerated, had suddenly become unacceptable to her. If she had contributed to a miscarriage of justice, even unintentionally, she had an ethical obligation to address it with the same decisiveness she had shown in imposing the sentence. Eleanor spent the remainder of the day reviewing the Johnson case file with new eyes, identifying points where her rulings had favored the prosecution, where she had accepted certain evidence without sufficient scrutiny, where her own unconscious assumptions might have influenced the proceedings. The exercise was professionally humbling and personally disturbing. By evening, she had reached a difficult conclusion. Her handling of the case had been procedurally correct according to legal standards, but potentially unjust in its practical effect. She had followed the letter of the law while perhaps losing sight of its spirit. Equal justice regardless of race, background, or circumstance. The revelation left her feeling unmoored, questioning decisions in countless other cases over her 17-year judicial career. How many other Marcus Johnsons might there be? How many lives potentially altered by unconscious biases she had never acknowledged, even to herself? As she prepared to leave for the day, her clerk appeared at her door. Judge Malone, there's a Ms. Parker here to see you. She says it's regarding tomorrow's hearing. Eleanor frowned. Vivian Parker? From the DA's office? Yes, Your Honor. She's quite insistent. Eleanor considered refusing the meeting. It was late, and ex parte communications were generally inappropriate, but her curiosity prevailed. Send her in. Vivian Parker entered with the measured confidence of a seasoned prosecutor. At 38, she had established herself as one of the district attorney's most effective courtroom advocates, known for methodical preparation and unflappable demeanor. Ms. Parker, Eleanor acknowledged, this is unexpected. Thank you for seeing me, Judge Malone, Parker replied, closing the door behind her. I understand you've scheduled an emergency hearing regarding the Johnson case for tomorrow morning. That's correct. New evidence has emerged that warrants immediate review. Parker nodded, her expression carefully neutral. I'm aware of the evidence. In fact, I'm here because of it, and because of certain concerns about how the district attorney's office is handling this matter. Eleanor's interest sharpened. Please elaborate. Parker hesitated, clearly weighing her words. Judge Malone, I was not the prosecutor assigned to the Johnson trial, but I've reviewed the case file thoroughly since the new evidence emerged. I have serious concerns about both the original prosecution and the current response to potentially exculpatory evidence. What specific concerns, Ms. Parker? The victim's identification of Johnson was problematic from the start. Cross-racial identification made under extreme stress, with the perpetrator partially masked. The alibi witnesses were more credible than characterized in court. And most troublingly, the recent robbery footage shows patterns so similar to the original crime that any objective analysis would flag significant reasonable doubt. Eleanor studied the prosecutor carefully. "You're effectively criticizing your own office's handling of this case, Ms. Parker." "That's an unusual position for a deputy DA." "I'm aware of that," Parker replied, her posture straightening slightly. "But my ethical obligation is to justice, not to maintaining convictions at all costs. I've raised these concerns internally and been instructed to stay in my lane. That's why I'm here." "What exactly are you proposing?" "Tomorrow I intend to inform the court that the prosecution has conducted a more thorough review than was previously reported, and that this review raises significant questions about the identification of Marcus Johnson as the perpetrator of the original robbery." Eleanor's eyebrows rose. "That position directly contradicts the official assessment I received from DA Harmon this morning." "Yes," Parker acknowledged. "It does." The implications hung in the air between them. A deputy district attorney preparing to publicly contradict her superior, potentially sacrificing her career in the process. "Why?" Eleanor asked simply. "Because an innocent man shouldn't spend 15 years in prison to protect institutional pride or conviction statistics," Parker replied. "And because I became a prosecutor to pursue justice, not victories at any cost." After Parker departed, Eleanor remained in her chambers, processing this unexpected development. The case that had seemed so straightforward during trial had revealed layers of complexity that challenged not just the verdict, but the functioning of the entire system, from police procedures to prosecutorial decisions to her own judicial oversight. The following morning, Courtroom 7B filled beyond capacity. News of the emergency hearing had spread rapidly through the legal community, drawing attorneys, law students, and courthouse staff curious about the unusual proceedings. Marcus Johnson sat beside his attorney, wearing prison-issued clothing, his expression a careful mask that couldn't fully conceal his hope and apprehension. Dr. William Johnson occupied the front row of the gallery, directly behind his brother. Beside him sat their mother, Grace Johnson, her back ramrod straight, her hands clasped tightly in her lap as if physically containing the emotions threatening to overwhelm her. Eleanor entered the courtroom, the traditional call to rise momentarily disrupting the buzz of speculation. As she took her seat, she noted the unusual arrangement at the prosecution table. Richard Harmon and Vivian Parker sitting side by side, tension evident in the careful distance they maintained between them. "This court is now in session," Eleanor began, her voice carrying the formal authority of her position while deliberately softening its typical severity. "We're here to review newly discovered evidence in the case of State versus Marcus Johnson. I want to emphasize that this is not an appeal proceeding but an extraordinary review based on potentially exculpatory evidence that was unavailable during the original trial." She turned her attention to the defense table. "Mr. Rodriguez, you may present your evidence." Rodriguez approached the podium with a confidence that had been absent during the original trial. "Your Honor, we have obtained security footage from a convenience store robbery that occurred 3 days ago, while my client was already in custody. The perpetrator matches the physical description, methodology, and specific behavioral patterns of the individual who committed the robbery for which Mr. Johnson was convicted." He introduced Dr. Sarah Chen, a forensic image analyst from the university's Criminal Justice Department, who presented a detailed comparison of the footage from both robberies, highlighting specific similarities in stance, movement patterns, and physical proportions that suggested the same individual had committed both crimes. "Based on my analysis," Dr. Chen concluded, "I can state with 92% confidence that these robberies were committed by the same individual. Given that Mr. Johnson was incarcerated during the second robbery, this strongly suggests he could not have committed the first." Eleanor turned to the prosecution table. "Mr. Harmon, your response?" Harmon rose, his usual commanding presence somewhat diminished. "Your Honor, the state maintains that this new evidence, while interesting, does not conclusively exonerate the defendant. Similarities in robbery techniques are common among criminals operating in the same area, and the image quality from both incidents makes definitive identification challenging." "Ms. Parker," Eleanor said, surprising the courtroom with her direct address to the deputy DA, Do you have anything to add to the state's position? A momentary silence fell as observers registered the unusual nature of this exchange. Prosecutors typically presented unified positions, with the lead attorney speaking for the entire office. Parker stood, straightening papers that didn't need straightening, a small tell of her nervousness that Eleanor recognized from countless courtroom appearances. Your Honor, after conducting my own review of the evidence, I must respectfully disagree with the official position of the District Attorney's Office in this matter. A murmur rippled through the courtroom. Harmon's head snapped toward Parker, his expression darkening. In my professional assessment, Parker continued, her voice steadying as she spoke, the new evidence creates substantial reasonable doubt about Mr. Johnson's involvement in the original robbery. When combined with the already questionable eyewitness identification and the credible alibi witnesses whose testimony was given limited weight during trial, I believe the interests of justice require acknowledging that this conviction may be fundamentally flawed. The courtroom erupted in whispered conversations. Eleanor allowed the moment to breathe before calling for order. Miss Parker, she said once quiet had been restored, are you stating for the record that the prosecution now has reasonable doubt about the defendant's guilt? Parker met Eleanor's gaze directly. Yes, Your Honor, I am. Harmon rose immediately. Your Honor, Miss Parker does not speak for the District Attorney's Office in this matter. Our official position remains that the conviction is sound and— Mr. Harmon, Eleanor interrupted, her tone sharp. Are you suggesting that a prosecutor in your office should suppress concerns about the potential innocence of a convicted defendant? Harmon faltered, caught between defending his authority and avoiding an ethically problematic statement. I'm suggesting that internal disagreements should be resolved before presenting positions to the court. And if those disagreements aren't resolved? Eleanor pressed. If a prosecutor believes an innocent person has been wrongfully convicted, what is their ethical obligation? The question hung in the air, its implications extending beyond this case to the fundamental principles of the justice system itself. Before Harmon could respond, the courtroom doors opened, and a uniformed police officer entered, approaching the defense table with purposeful strides. He handed a document to Rodriguez, who read it quickly, his expression transforming from confusion to vindication. Your Honor, Rodriguez said, rising to his feet, I've just received notification that police have apprehended a suspect in the recent string of convenience store robberies, a Jerome Wilson. According to this report, Mr. Wilson has confessed to 5 robberies over the past 2 months, including the one for which my client was convicted. This time, Eleanor made no attempt to quiet the reaction that swept through the courtroom. The gasps of surprise, the exclamations of shock, the tearful embrace between Grace Johnson and her son William. At the defense table, Marcus Johnson lowered his head, shoulders shaking with silent emotion as the possibility of vindication of freedom suddenly crystallized from abstract hope into tangible reality. Eleanor allowed herself a moment to absorb the implications of this development, to acknowledge the profound failure of the system she had served and defended for her entire career. A system that, despite its procedural safeguards and constitutional protections, had convicted an innocent man and would have imprisoned him for 15 years but for a coincidence of timing and the persistence of his family. And her own role in that failure, the unconscious biases she had never examined, the presumptions she had never questioned, the certainty she had never doubted, could no longer be denied or minimized. In light of this development, Eleanor said, her voice cutting through the commotion, this court will take a 30-minute recess. Mr. Harmon, Ms. Parker, I expect you to review this confession immediately and be prepared to state the prosecution's position regarding Mr. Johnson's conviction when we reconvene. As Eleanor rose to leave the bench, her gaze met Marcus Johnson's across the courtroom. In his eyes, she saw not the hardened criminal she had imagined during sentencing, but a man whose life had nearly been destroyed by a system that had failed its most fundamental purpose, to distinguish the innocent from the guilty and to deliver justice without prejudice or presumption. The realization settled over her with the weight of irrefutable truth. She had been wrong, not just procedurally or legally, but morally and ethically wrong in her approach to this case, and perhaps countless others throughout her judicial career. And with that recognition came another, equally powerful, the opportunity, no, the obligation, to use this moment not just to correct a single injustice, but to transform her understanding of justice itself. Eleanor Malone remained in her chambers during the recess, the weight of the unfolding events pressing upon her with each passing minute. The confession of Jerome Wilson had shattered her remaining certainty about the Johnson case, exposing not just a miscarriage of justice, but the fragility of a system she had defended without question throughout her career. Her phone buzzed insistently, reporters seeking comment, colleagues curious about the unusual proceedings, even a text from the chief judge asking for an explanation of the emergency hearing she had called without prior consultation. Eleanor ignored them all, focusing instead on the decision that now loomed before her. A knock at her door interrupted her thoughts. "Enter," she called, expecting her clerk with updates from the prosecution's review of Wilson's confession. Instead, Catherine Malone stepped into the chamber, her expression a complex mixture of concern and determination. At 24, she bore a striking resemblance to Eleanor at the same age, the same analytical gaze, the same set of her jaw when confronting difficult truths. "Catherine?" Eleanor rose from her desk, surprise momentarily displacing her professional composure. "What are you doing here? Shouldn't you be in class?" "I saw the news about the Johnson hearing," Catherine replied, closing the door behind her. "It's all over legal Twitter. Judge Malone calls emergency hearing, potential wrongful conviction. I caught the first train down." Eleanor gestured to a chair, resuming her seat behind the desk. The familiar barrier of formality seemed necessary now, even with her daughter. "It's a complicated situation." "Is it?" Catherine asked, her directness a mirror of Eleanor's own courtroom manner. "From what I'm hearing, it sounds like an innocent man was convicted based on questionable identification, and now the actual perpetrator has confessed." "The facts are still being verified," Eleanor replied, her tone measured. "The prosecution is reviewing Wilson's confession as we speak." Quote, Catherine studied her mother, seeming to look past the judicial mask to the uncertainty beneath. "Mom, I'm not here to debate the case. I'm here because I know what this means for you, what it costs you to acknowledge this kind of mistake." The simple statement, delivered without judgment or accusation, pierced Eleanor's professional armor more effectively than any criticism could have. Her daughter understood, perhaps better than anyone, the fundamental beliefs that had shaped Eleanor's approach to justice. Beliefs now revealed as dangerously incomplete. "It's not just about this case," Eleanor admitted, the words difficult to form. "If I was wrong about Johnson, if I allowed my assumptions and biases to influence my handling of his trial, how many other defendants received less than full justice in my courtroom?" Catherine leaned forward, her expression softening. "That's exactly why I'm here. Because I knew you'd be asking that question, and because I think it's the right question to ask." "What do you mean?" "Most judges in your position would be looking for ways to minimize this, to frame it as an aberration, a rare exception that doesn't challenge their overall approach. But you're questioning everything, aren't you? Your entire judicial philosophy." Eleanor nodded, a small gesture of vulnerability she rarely permitted herself. 17 years on the bench, Catherine, thousands of cases. If my judgment was this flawed in Johnson's case, how can I trust it was sound in others?" "Maybe you can't," Catherine replied simply. "Maybe none of us can trust our judgment absolutely. Maybe the recognition of that fallibility is exactly what justice requires." The wisdom in her daughter's words struck Eleanor with unexpected force. Throughout her career, she had equated certainty with strength, doubt with weakness. She had believed that justice required firm, unwavering judgment, that hesitation or second-guessing undermined the authority necessary to uphold the law. But what if the opposite were true? What if justice required constant questioning, persistent doubt, ongoing examination of one's assumptions and biases? What if the greatest threat to justice wasn't uncertainty, but its absence? The dangerous certainty that prevented recognition of error. "When did you get so wise?" Eleanor asked, a small smile breaking through her professional reserve. "I had a good teacher," Catherine replied. "You taught me to question everything, to look beyond surface appearances for deeper truths. You just applied that principle differently in your professional life than you did at home." The observation was incisive and undeniable. Eleanor had raised her daughter to think critically, to challenge assumptions, to seek evidence before forming conclusions. Yet in her courtroom, she had often relied on patterns and probabilities, on statistical likelihoods rather than individual circumstances, on a presumption of guilt masked as impartial assessment. "What happens now?" Catherine asked. "With Johnson? If Wilson's confession is verified and the prosecution acknowledges the error, I'll vacate the conviction immediately. Johnson will be released today. And after that?" Eleanor understood the deeper question, not about procedural next steps, but about personal reckoning. "I don't know yet. This changes everything, Catherine. My understanding of my role, my approach to every case. I can't simply return to business as usual." Before Catherine could respond, a knock at the door announced Eleanor's clerk. "Judge Malone, the attorneys are ready to proceed. And there's someone else asking to address the court. Mr. Kim, the victim from the original robbery." Eleanor's surprise must have been evident, as the clerk added, "He says it's important, Your Honor, that he needs to speak before you make your ruling." Eleanor nodded, processing this unexpected development. "Tell them I'll be there in 5 minutes." After the clerk departed, Eleanor turned back to her daughter. "I need to go." "I know," Catherine replied, rising from her chair. "I'll be in the gallery. Just remember what you always told me when I was facing difficult decisions. The measure of character isn't in never making mistakes, but in how we respond when we discover them." Eleanor recognized her own words, spoken to her daughter after a high school incident years earlier. The wisdom she had offered as a parent now returned to guide her as a judge, a perfect circle of teaching and learning that transcended their respective roles. When Eleanor re-entered the courtroom, the atmosphere had transformed. Word of Wilson's confession had spread, creating a buzz of anticipation that hushed only when she took her seat at the bench. Marcus Johnson sat straighter at the defense table, hope visibly warring with caution in his expression. Beside him, James Rodriguez appeared quietly confident, his usual defensive posture replaced by the calm certainty of vindication. At the prosecution table, Richard Harmon sat alone, Vivian Parker's absence a notable statement in itself. "This court is back in session," Eleanor began, her voice carrying a different quality than it had that morning. Less automatic authority, more thoughtful purpose. "Before addressing the new evidence, I understand Mr. Sung-Ho Kim wishes to address the court. Is Mr. Kim present?" From the back of the courtroom, a slender man in his 70s moved slowly toward the front, assisted by a middle-aged woman who appeared to be his daughter. Mr. Kim had been the victim of the original robbery, the one whose testimony had been central to Marcus Johnson's conviction. His face still bore faint scars from the pistol whipping he had suffered during the crime. As he approached the witness stand, Eleanor noticed his hands trembling slightly. Whether from age, emotion, or both, she couldn't determine. "Mr. Kim," she said gently after he had been sworn in, "the court appreciates your presence today. Please share what you wish to say." Mr. Kim gripped the railing of the witness stand, his English accented but clear. "Your Honor, I have come because I must tell the truth. When I identified Mr. Johnson as the man who robbed my store, I believed I was correct. I was certain of it." He paused, glancing toward Marcus Johnson with an expression of profound regret. "But the police showed me his picture before the lineup. They said, 'We caught him, we just need you to confirm.' I wanted so badly for them to have caught the man who hurt me, who threatened to kill me if I didn't empty my register." A murmur rippled through the courtroom. This revelation of procedural impropriety, of police suggesting Johnson's guilt before the identification, had not emerged during trial. "The detective, he showed me the photo and said, 'This is him, right?' And after looking at it, when I saw Mr. Johnson in the lineup, my brain told me it was the same man. I truly believed it was him." Mr. Kim's daughter placed a supportive hand on his shoulder as he continued. "Yesterday, the police came to my store again. They showed me a different man's picture, this Wilson, and asked if he was the one who robbed me. And I knew immediately, this was the man. The shape of his eyes, the way he held himself. It all came back clearly." He turned toward Marcus Johnson directly. "I am so sorry, Mr. Johnson. I never wanted an innocent man to suffer. I believed I was telling the truth, but I was wrong. My mistake has cost you too much." The simple, heartfelt apology cut through legal procedures and formalities, reducing the case to its human essence, a tragic error that had nearly destroyed an innocent man's life. Many in the courtroom, including several jurors from the original trial who had returned to witness the proceedings, were visibly moved. Eleanor thanked Mr. Kim for his courage in coming forward, then turned to Richard Harmon. Mr. District Attorney, in light of Mr. Kim's statement and the confession from Jerome Wilson, what is the prosecution's position regarding Mr. Johnson's conviction? Harmon stood, his usual commanding presence diminished by the circumstances. Your Honor, after reviewing the confession and corroborating evidence, the state acknowledges that a serious miscarriage of justice has occurred. We move to vacate Marcus Johnson's conviction immediately and dismiss all charges with prejudice. Where is Ms. Parker? Eleanor asked, noting again the Deputy DA's absence. Harmon's expression tightened. Ms. Parker has been placed on administrative leave pending review of her actions in this matter. For what specific actions, Mr. Harmon? For raising concerns about a wrongful conviction? For fulfilling her ethical obligation to seek justice rather than merely win cases? The question hung in the air, challenging not just Harmon's decision but the culture that had produced it. A culture that prioritized conviction rates over accuracy, that treated acknowledgement of error as weakness rather than integrity. Before Harmon could formulate a response, the courtroom doors opened, and Vivian Parker entered, walking with purposeful strides to stand beside the prosecution table. Ms. Parker, Eleanor acknowledged, I understood you had been relieved of your duties on this case. I have been, Your Honor, Parker replied, her voice steady despite the career risk she was taking. But before I leave, I felt obligated to inform the court of certain facts relevant to these proceedings. Eleanor sensed the shift in the courtroom, the heightened attention, the awareness that something unprecedented was unfolding. Please continue. Your Honor, the confession from Jerome Wilson is not the first indication of Marcus Johnson's potential innocence that the District Attorney's Office received. 3 weeks ago, during initial preparation for trial, I flagged concerns about the eyewitness identification and requested additional investigation. That request was denied. Harmon stepped forward. Your Honor, this is an internal matter that— No, Mr. Harmon, Eleanor interrupted. This is a matter of justice, of whether your office pursued truth or merely conviction. Ms. Parker, please continue. Parker nodded. 2 weeks ago, another convenience store was robbed in a manner identical to the crime attributed to Mr. Johnson. I requested comparison of security footage from both incidents. That request was also denied. She turned slightly to face Harmon directly. The prosecution has an ethical obligation to pursue justice, not just convictions. When evidence suggests we may be prosecuting an innocent person, we have a duty to investigate fully, not to press forward regardless of doubts. The courtroom had fallen completely silent, each person present witnessing a rare moment of institutional self-examination being played out in public view. And why are you sharing this now, Ms. Parker? Eleanor asked, though she suspected she already knew the answer. Because the system only works when we acknowledge its failures openly, Parker replied. Because burying mistakes ensures they'll be repeated. And because Marcus Johnson deserves to know that his wrongful conviction wasn't just bad luck or an honest mistake, it was the result of systemic choices that valued efficiency in conviction rates over thorough investigation and justice. Eleanor considered Parker's words, recognizing in them the same uncomfortable truth she herself had been confronting. That individual errors in judgment were inseparable from the systemic incentives and cultural assumptions that shaped them. She turned to Marcus Johnson, who had listened to these revelations with remarkable composure given their implications for the 14 months he had already spent in custody. Mr. Johnson, please rise. Marcus stood, his dignity intact despite the prison uniform, despite the handcuffs that should never have been placed on his wrists. Based on the evidence presented today, including the confession of Jerome Wilson, the testimony of Mr. Kim, and the statements of the District Attorney's Office, this court hereby vacates your conviction and dismisses all charges with prejudice. Eleanor paused, knowing that the legal pronouncement, while necessary, was woefully inadequate to address the injustice Marcus Johnson had suffered. Mr. Johnson, the court recognizes that no words can restore the time you have lost or undo the trauma you have experienced. The system failed you, failed in its most fundamental purpose of distinguishing the innocent from the guilty and delivering justice without prejudice or presumption. She continued, her voice carrying the weight of personal as well as institutional responsibility. As the judge who presided over your trial and imposed your sentence, I bear a particular responsibility for that failure, for that I offer my deepest and most sincere apology." The courtroom remained silent, the unprecedented nature of a judge publicly acknowledging error and offering a personal apology creating a moment that transcended normal procedural boundaries. "Bailiff, please remove Mr. Johnson's restraints immediately." As the bailiff unlocked the handcuffs, Marcus rubbed his wrists, the simple gesture a powerful symbol of freedom restored. His mother rushed forward from the gallery, embracing him with tears streaming down her face. Dr. William Johnson joined them, the family reunion creating a center of profound emotion within the formal courtroom setting. Eleanor waited for the initial wave of emotion to subside before addressing the broader implications of the case. What has happened here today extends beyond a single wrongful conviction. It requires all of us involved in the administration of justice to examine the assumptions, biases, and systemic practices that can lead to such errors. She looked directly at Richard Harmon. It requires prosecutors to remember that their duty is not to win cases but to seek justice, even when that means acknowledging doubt, investigating exculpatory evidence, or conceding error. Her gaze moved to the defense table. It requires defense attorneys to persist in challenging evidence and assumptions, even when the system seems stacked against their clients. Finally, she turned to address the whole courtroom. And it requires judges, myself included, to question our own certainties, to recognize the unconscious biases that can influence our perceptions, and to approach each case with genuine presumption of innocence rather than unstated presumption of guilt. In the gallery, Eleanor caught sight of her daughter Catherine, who offered a small nod of acknowledgement, not of Eleanor's position or authority, but of her willingness to confront uncomfortable truths and accept personal responsibility for systemic failure. As the formal proceedings concluded, Marcus Johnson approached the bench, a breach of usual protocol that Eleanor allowed without comment. "Judge Malone," he said, his voice steady despite the emotion visible in his eyes, "I want you to know something." "Yes, Mr. Johnson?" "I could have become bitter in prison. Many do. I could have let anger consume me, turned my back on a system that failed me so completely." He paused, seeming to choose his words carefully. "But my mother raised me to believe that how we respond to injustice defines us more than the injustice itself. And my brother taught me that systems don't change unless people within them are willing to acknowledge failures and work to correct them." Eleanor listened, struck by the wisdom and grace from a man who had every right to rage against the system that had wronged him. "What you did today, acknowledging the error, taking personal responsibility, that matters. Not just for me, but for others who might face the same injustice. Real change starts with people willing to say, 'I was wrong,' and then do something about it." In that moment, standing before a man whose life she had nearly destroyed through a combination of unconscious bias and systemic failure, Eleanor Malone made a decision that would reshape the remainder of her judicial career. 3 months later, Eleanor stood before a gathering of judges, prosecutors, defense attorneys, and criminal justice reform advocates in the courthouse's main conference room. The occasion was the launch of the Judicial Accountability and Reform Initiative, a program she had developed in partnership with Marcus Johnson, William Johnson, and Vivian Parker, who had resigned from the District Attorney's office to join a civil rights organization. "The American justice system is founded on noble principles," Eleanor began, her voice carrying the authority of experience tempered now by humility. "Equal justice under law, presumption of innocence, due process. Yet too often, we who administer this system fail to live up to those principles. Not through malice or deliberate corruption, but through unconscious bias, through cultural assumptions, through institutional practices that prioritize efficiency over accuracy." She gestured to Marcus Johnson, who stood nearby. 3 months ago, I presided over the exoneration of an innocent man who had been convicted in my courtroom. That experience forced me to confront uncomfortable truths about my own approach to justice. Assumptions I had never questioned, biases I had never examined, certainties I had never doubted. The room remained silent, her fellow judges particularly attentive. Many had privately questioned her decision to so publicly acknowledge error, seeing it as undermining judicial authority. Others had recognized the courage it required and the potential for meaningful reform it created. "The initiative we launched today has 3 core components," Eleanor continued. "First, a comprehensive review of cases where identification evidence played a central role in conviction, particularly cross-racial identifications made under stress or limited visibility conditions." She nodded toward William Johnson, who had taken a sabbatical from his surgical practice to help develop the program. Second, mandatory training for judges, prosecutors, and defense attorneys on unconscious bias, eyewitness reliability, and the psychological factors that can lead to wrongful convictions. Finally, she turned to Vivian Parker. And third, the establishment of an independent review board composed of legal professionals and community members to evaluate claims of innocence outside the traditional appellate process, which too often focuses on procedural correctness rather than factual accuracy. His story had become a powerful catalyst for reform, humanizing statistics about wrongful convictions and forcing acknowledgement of the lives disrupted or destroyed by systemic failures. William Johnson had established a foundation providing medical and psychological support to exonerees, addressing the often overlooked health consequences of wrongful incarceration. And Vivian Parker had become a leading voice for prosecutorial ethics reform, challenging the culture that measured success by conviction rates rather than just outcomes. As for Judge Eleanor Malone, she had chosen not to resign or retire, though many had expected her to do so after such a public acknowledgement of error. Instead, she had recommitted herself to the bench with a fundamentally transformed understanding of her role, not as an arbiter of guilt or innocence, but as a guardian of procedural fairness and constitutional protection, not as a defender of the system's infallibility, but as a constant questioner of its assumptions and practices. The path forward was neither simple nor clear. Institutional resistance to change remained strong, resources for comprehensive review were limited, and the human tendency toward certainty, toward believing in one's own objectivity, despite evidence to the contrary, remained a constant challenge, even for those committed to reform. But in the face of an innocent man who had found within himself the capacity for forgiveness rather than bitterness, who had chosen to transform his suffering into purpose rather than allow it to define him, Eleanor had discovered a similar capacity within herself: to acknowledge failure without being diminished by it, to learn from error rather than deny it, to grow from challenge rather than retreat from it. As the gathering dispersed, Eleanor found herself standing beside Marcus Johnson near a courthouse window overlooking the city where he had nearly lost his freedom and where he now worked to reform the system that had failed him. "Do you think it will make a difference?" she asked, echoing a question she had often considered during the development of the initiative. "These reforms, this program, will it actually prevent what happened to you from happening to others?" Marcus considered the question with the thoughtfulness it deserved. Throughout his ordeal, he had maintained a remarkable capacity for nuanced perspective, neither dismissing the importance of a functioning justice system, nor accepting its failures as inevitable. "Not completely," he answered honestly. "Systems are imperfect because people are imperfect. There will always be errors, biases, mistakes." He turned slightly to face her directly. "But every case where someone like you or Ms. Parker stops to question assumptions, to challenge certainties, to look beyond the obvious for deeper truths, that's a case where injustice might be prevented. And every time someone in power admits they were wrong and works to do better, that creates ripples that change how others approach their responsibilities." He gestured toward the city beyond the window. "I don't expect perfection, Judge Malone, but I believe in the power of people willing to face uncomfortable truths and then act on them. That's how real change happens. One difficult conversation, one acknowledged error, one reformed practice at a time." As they stood together, the judge who had sentenced an innocent man and the man who had found the capacity to forgive her, they embodied the complex, imperfect, essential process of human justice, flawed but improvable, broken but repairable, capable of both terrible error and remarkable redemption. Their story was not one of perfect resolution or complete transformation, but of the messy, ongoing work of building a more just system, a system that acknowledged its failures, learned from its mistakes, and remained ever vigilant against the comforting but dangerous certainty that justice had already been achieved, rather than remaining a constant aspiration requiring perpetual effort and attention. Up next, you've got two more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out. And don't forget to subscribe and turn on the notification bell so you don't miss any upload from us.